Hello and welcome back to the Hogan Lovells webinar series on the EU Digital Services Act. My name is Marvin Jäschke. I'm an attorney and associate at Hogan Lovells in Hamburg, focusing on regulatory issues relating to online platforms. In the last two episodes, we've started our DSA journey by exploring various aspects of the DSA, such as its history and territorial scope, and the different types of intermediary service providers and their liability for third-party content. Today, we're going to take a closer look at the other side of the coin, namely the various obligations of intermediary service providers with respect to moderating said third-party content. Bear in mind, however, that the DSA imposes different levels of obligations for different types of intermediary service providers. In this episode, I will summarize the basic content moderation obligations that all intermediary service providers must follow before focusing on the more advanced content moderation obligations that apply to hosting providers, including online platforms and so-called VLOPs. There are also more advanced obligations that only apply to online platforms and VLOPs. These obligations will be covered in a future episode of this series. To start our introduction to content moderation, let's have a look on the different legal terms and definitions as provided by the DSA itself. In the broad field of third-party content moderation, the DSA provides two main definitions. Content moderation is broadly defined as follows: any activity by the provider that aims to detect, identify and address content provided by the user that is either illegal or incompatible with the service's terms and conditions. The DSA also provides us with a definition of illegality. According to this definition, content is illegal if it is, in itself or in relation to an activity, not compliant with union law or with law of a member state compliant with union law. It is important to emphasize that the definition itself does not specify any particular illegal activity. Contrary to popular belief, the DSA does not prohibit hate speech or similar activities. Instead, the DSA relies on other legal provisions to determine what is illegal. Please note that the illegality is independent of the subject matter or nature of the law. In terms of content, content moderation can cover anything from terrorist content and hate speech to copyright infringements and fraudulent behavior. That said, we cannot find a definition of incompatibility. Following Article 3 of the DSA, terms and conditions are broadly understood to include all clauses, irrespective of their name or form, which govern the contractual relationship between the intermediary and the recipient. This includes, for example, community standards and content policies. From these definitions, we can infer that content moderation is a complex concept based on two reasons that can include various measures, for example, the removal or demotion of content and the suspension or termination of a user's account. While the distinction between the different reasons is clear on paper, it is often not easy to make in practice, as there are naturally some overlaps. For example, illegal content often constitutes a violation of the service's terms and conditions, since it is usually explicitly prohibited. And while the term is not used directly by the DSA, there is also the notion of harmful content, which is typically used in community standards and guidelines, or, as we have just learned, in the terms and conditions. Harmful content is not necessarily illegal, but it can still be harmful to specific user groups. It may include hateful or explicit language, misinformation, or adult content that is inappropriate for minors. Misinformation, for example, might be harmful content, but is not illegal. If the provider wishes to take action against such content, it must specify this in its guidelines and policies. The only way to handle this is to adjust the policies, and this is something we regularly assist with. So, to sum it up, content moderation refers to any activity by a provider relating to third-party content that is illegal or incompatible with the terms and conditions of the service. Now, let's take a look at the basic content moderation obligations for all intermediary service providers, including hosting providers. With regard to various obligations relating to content moderation, it is initially useful to distinguish between the parties to whom the obligations apply. All intermediary services, ranging from caching and conduit services to very large online platforms, have basic obligations. These obligations include, above all, compliance with orders issued by national authorities. These orders may request the removal of specific illegal information from the service or the provision of user information to the authorities. However, the DSA itself does not provide a legal basis for these orders, and the relevant authority must present the legal basis to the provider. In addition, all intermediary service providers must be transparent to some extent regarding content moderation. This includes the terms and conditions as well as an annual reporting obligation. Hosting providers, on the other hand, must provide a notice and takedown mechanism, a statement of reasons, and notification of criminal offenses to law enforcement agencies. Let's focus on the left-hand side for a moment, especially the two transparency obligations for all intermediary service providers. Under Article 14 DSA, intermediaries are obliged to clearly outline any restrictions they impose on the use of their service in the terms and conditions. This includes content policies, the procedures and measures in place, as well as tools used for content moderation and the rules how to handle internal complaints. All of this must be drafted in a clear, plain, intelligible and user-friendly language and must be made publicly available and easily accessible. Please also note that very large online platforms are also required to present a comprehensive summary of terms and a version of the terms in every official language of a member state where the service is offered. Additionally, all intermediaries are obliged to inform users of any significant change to the terms, leaving lawyers and providers alike with the tricky question of what makes a change significant and which can only be assessed on a case-by-case basis. For intermediary service providers, this means that they must review their own policies and, where necessary, adapt them to ensure that they comply with the requirements of Article 14 DSA. With regards to the annual reporting obligation, the reports must be clear, easily comprehensible, and available in a machine-readable format. They need to detail the content moderation activities undertaken during the reporting period, including different metrics regarding the content moderation, for example, the number of removal orders received and actioned, and the number of own initiative content moderation by the provider. Please note again that there are even further obligations for online platforms and VLOPs following Article 24 and 42 DSA. And from the 1st of July 2025, providers are obliged under the implementing regulation provided by the European Commission to collect the data using uniform templates to harmonize the report's structure and make them easily comparable. And this template truly is both a blessing and a curse. On the one hand, the clear guidance by a template, of course, is beneficial. On the other hand, it is quite challenging to work with a template, as its predefined categories often do not align with the categories previously used in the industry and that are also difficult to distinguish from one another. These issues are particularly evident in the three categories of incitement, harassment, and bullying, whose boundaries are often blurred. In order to meet the new requirements more effectively, content moderation should therefore be linked to transparency reporting by interlocking both mechanisms. We have now seen that there are basic content moderation obligations for all types of intermediary service providers under the DSA. Now, we want to focus on the core content moderation obligation, the notice and action mechanism that applies only to hosting providers. Please remember, a hosting service consists of the storage of information provided by and at the request of a recipient of the service, which means that online platforms and VLOPs are also hosting providers and are subject to the following obligation as well. Under Article 16 DSA, hosting providers are required to provide a mechanism that allows any individual or entity to report illegal content on the service easily and in a user-friendly manner and close to the content in question. You will certainly have seen this reporting functionality on the internet yourself. However, there are some things that must be pointed out here to demonstrate its relevance under the DSA. According to the law, any individual or entity must be permitted to file a notice. This seemingly does not take legal standing into consideration, which, to be frank, would be an extraordinary and non-imperative decision with regard to the exclusive rights of individuals. Further on, the notice and action mechanism is a crucial instrument in the distribution of liabilities because a sufficient notice under Article 16 can constitute actual knowledge, meaning the exclusion from the liability privilege under Article 6 DSA. In other words, once reported sufficiently, the hosting service provider will be liable for the reported content if the provider fails to act promptly upon receipt. This usually is realized by a report button, often separately for every third-party content on the web page. According to Article 16, the intake channel then must enable and facilitate that a notice contains the following elements. A. An explanation of reason why the content is supposed to be illegal, and B. The indication of an exact location, mainly referring to the Uniform Resource Locator, to clearly identify the piece of content. Both is especially important because a provider is not required to legally examine the content in detail. In addition to that, the mechanism should also allow C. a bona fide statement, and D. following the recitals, the possibility for the notifier to state name and address. However, in some cases, especially concerning intellectual property rights, it might be necessary for the notifier to identify him or herself as the rights holder, as otherwise the provider cannot easily assess the illegality of content. In other cases, namely in context of child sexual abuse of material, an anonymous notice must be possible by law. That all said, whether a notice is sufficient is a case-by-case decision. To mitigate enforcement risks, a more generous approach might be recommended, but in particular with regards to IP infringements, a more restrictive approach is defensible. So, this is how a DSA-compliant reporting form could look like. Again, please note that in this example, the name and email address should be optional. Also note that while it is recommended to provide a notifier with a list of possible reasons to choose from for better channeling and prioritizing the notices, this list must not be exhaustive and users should be able to provide a reason by their own. Following a notice, the provider must inform the notifier, where possible, of the receipt of the notice. And the compliant notification could look like this. And last but not least, after the decision, the notice submitter must be notified of the outcome and his or her options for redress. Simple, right? Well, as the saying goes, the devil is in the details. And we know from experience that implementing a compliant notice and action mechanism can be challenging depending on the business model and, of course, the client's individual needs. In recent years, while preparing for the designation and the DSA to come into force, we have received many questions from clients regarding content moderation. And here are just a few of the most frequently asked. Many questions naturally concern automated means. For example, is automated processing still allowed? And if so, can we automatically reject notices from non-EU entities? What about entities without legal standing? And what if a notifier uses a channel not designated for DSA reports? Regarding the design of the reporting channel, can we make the name and email address fields mandatory to protect against misuse, at least in some cases? And what about other reporting channels? Is DSA compliance now an overarching requirement? Last but not least, concerning the decision process, can we assess content that is allegedly illegal against our own platform rules instead? What does timely mean? Is there a fixed deadline? What criteria come into play when assessing a timely decision? The DSA is vague in many areas, so it is impossible to answer the above questions with a simple yes or no. There are often valid arguments on both sides. We cannot go into all the details here, but if you have any questions, please remember, we are only a few clicks and a call away. That said, let's move on to the last obligation of this session. Closely linked to the notice and action mechanism is the obligation for hosting providers to provide a statement of reasons according to Article 17 DSA. The second obligation specific to hosting providers concerns the provision of a statement of reasons following the content moderation. This statement of reasons must be provided to the affected user, which is in most cases, of course, the uploader of the moderated content, but can also mean the unsuccessful notice submitter. Exceptions to these obligations are rare and only apply to removal orders following Article 9 DSA and in cases of what the DSA, without further explanation, calls deceptive high-volume commercial content. Again, the vague wording here poses some challenges, and the interpretation of this exception might vary between different services. Interestingly, this obligation applies for both restrictions of illegal content and content that is incompatible with the terms and conditions of the service. Regarding the minimum of information, a statement of reasons demands information about nature, scope, and duration of a moderation measure, the facts and circumstances the decision is based on, whether the information was based on automated means, and the legal ground or contractual ground of the decision. Last but not least, the statement of reasons will require the information about possible redresses. In case of online platforms, this in particular will include the internal complaint mechanism following Article 20 DSA and the out-of-court dispute resolution under Article 21 DSA. Both obligations will be presented to you in the next episode of this series. As a rule of thumb, if the statement of reasons puts the user into a position to understand why the decision was taken and what he or she can do about it, the statement of reasons will typically be sufficient. Please also note that following Article 24 DSA, online platforms and VLOPs are also obliged to register and submit their statements of reasons, of course without any personal data and without undue delay, to a public transparency database provided by the European Commission. So, to visualize the before said, here is how a statement of reasons compliant with Article 17 DSA may look like, stating the facts and circumstances of the case, namely a listing offered on a marketplace without packaging, the nature and scope of measures, namely the removal of the listing, the contractual grounds, namely paragraph 5 of the terms and the respective cosmetics policy, and the information about the use of automated means. And, last but not least, the possible redresses. Here, the internal complaint, the out-of-court settlement body, and the review by a competent national court under the applicable laws. And this concludes our third episode of this webinar series. Thank you for watching. In the next episode, we will dive even deeper into the content moderation obligations for online platforms and VLOPs. Stay tuned and see you soon.